Again, welcome you to this evening seminar of Mr. Sidharth Luthra. The guest will be on screen in a few minutes. He's got some problem. He'll be there on the screen within a few minutes. Please bear with us.
Good evening, everybody. Today's session is addressed by Mr. Sidharth Luthra, the eminent criminal lawyer, Supreme Court, former Additional Solicitor General of India. He carries the legacy of his father, late Mr. K.K. Luthra, who was also an eminent lawyer. Sir is the member of Delhi Legal Services Authority, and he is also the Vice President of Indian Criminal Justice Society. He has been appointed as amicus curiae in various cases by the Supreme Court. At my personal level, I would say that he has helped me a lot. He has advised me in lots of matters, and his advices never went wrong. Sir, I should thank you, sir, for coming today, accepting my invitation, sir. I welcome you to address the topic of the day, an overall view of the Prevention of Money Laundering Act, sir. Please, sir.
Thank you so much. I'm sorry I'm joining from a remote location.
Okay,
so
sir.
I hope the signal in the video is good. Just one clarification. My dear friend Ravindran is too kind to me, but a correction. He referred to a lawyer. I always say lawyers practicing criminal law sound better than calling some criminal lawyer. The distinction becomes very dim and says, I think the field of criminal law, you don't want to be known as a criminal lawyer. Lawyer practicing criminal law is much.
I stand corrected, sir.
After all, the judge handling the criminal roster is never called a criminal. So why should lawyers be called criminal lawyers? But that's the distinction. I think it's the distinction that civil lawyers make. They believe that civility is their domain and not those practicing criminal law. So we'll go with the flow. Okay, so what we'll do is I have a short PowerPoint presentation which I'm going to take you guys through and share some of my thoughts about this legislation. I also want you to, then we leave the floor open for 15 minutes for questions. I hope that's good enough.
Yes, sir. Yes, sir.
So let me just try and find my presentation for a moment.
Yes, sir.
Just a minute. Okay, I think that should be just a moment. Is that working out?
Yes,
Yes,
sir.
sir. Yes, sir. Yes, sir. Yes, sir.
Okay. Good evening once again, everyone. I'm going to take you through some of my thoughts on the PMLA. The Prevention of Money Laundering Act is a very interesting legislation. Historically, this legislation, as you know, was brought in 2002, but notified only in 2005. Why was it brought in? It was brought in to ostensibly prevent money laundering, to provide for attachment, seizure, and confiscation of property obtained or derived directly or indirectly from or involved in money laundering, and to create criminal prosecutions. Now, if you look back traditionally, there is a law called the Criminal Law Amendment Ordinance of 1944. I'm sure you're acquainted with that. The Criminal Law Amendment Ordinance also created a mechanism for attachment of proceeds of crime. There are also provisions in the CRPC sections 451 to 457 to attach or take away proceeds of crime to as a form of recompense, so to speak. Now, these are all mechanisms that were tried and tested, but it was felt, and also there's an issue of international treaties and understandings, that even in criminal cases, if you prosecuted somebody, you could prosecute them, but that did not necessarily translate into access to the proceeds of the criminality. Of course, in income tax and other laws, it used to be attached and penalty used to be imposed. But under the criminal law, this was not so. So the question really was, should we not hit out at people who benefit from crime? You punish them, but if they still continue to benefit from the proceeds, then the system needs a rectification. In our neighboring country, in Pakistan, they've come out with a very interesting thing. They came up with a thing called the VIS-À-VIS Act. Initially, it was the National Accountability Ordinance, NAB, and later called the VIS-À-VIS Act, which meant that people who had committed crime could go to the government if the government prosecuted and go there, enter into an agreement with the sovereign government and actually pay back the amounts. Otherwise, the government would confiscate all their resources and their assets. That's unique to certain jurisdictions. That law has been upheld by the Pakistan Supreme Court. But in our country, there was this gap in the law which the PMLA was sought to be brought in for. We must also remember that the PMLA empowers the Enforcement Directorate. Now, the Enforcement Directorate used to be one of the most powerful and most dreaded investigation organizations because they had immense powers under FERA. And for many, many years, they were lying toothless because FERA had been replaced with FEMA, which does not have criminal sanctions, and the power to arrest was taken away. So suddenly with the PMLA coming in, the ED got a new life. They became rejuvenated. They became a lot more relevant. And therefore it has given rise and strength to an organization which some in government believe was underutilized. I have my own views on it, but we'll leave that for another day. Now, just that I've given you the background just to, let you know. So this business of, money laundering, the question really is, what is money laundering? I don't know if you know where money laundering comes from. It's a very interesting concept. In the 1920s, when they had prohibition in the USA, a lot of money was made from illicit liquor. The question was, how do you convert that money from black to white? So, that is, how do you make this tainted money which is proceeds of crime, into alleged paid money? So what the underworld did in the US, especially New York, Chicago, that they set up laundrettes, where people could go and wash their clothes. And they used to take the money and show money which people had come and washed clothes. And that is where you get the word money laundering from, because there were laundrettes where washing machines used to be put, where clothes could be washed, but actually they were only a mechanism to show receipt of money for which there was no legitimate source. So in India, we brought in PMLA, and it uses the definition, whoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceed of crime, including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property. Now the last part is very important. Projecting or claiming it as untainted property. This is the most crucial part of the definition. Unfortunately, anybody who is said to be in possession, so even a lawyer who receives fees, can be questioned, because if it's tainted property that's come to the lawyer, he can be questioned. Though, speaking for the lawyer, he has charged a fee and earned the money genuinely. Section 4, of course, makes it a punishable offense. Now, this act also has a wonderful definition called what are proceeds of crime. Now, this is a very crucial definition sought to be diluted with the new amendments. Originally, as you can see, it talked about property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. Now see the next part. Or the value of any such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. So this business value of any such property has led to a great debate, because what is happening is there is what is colloquially called double attachment. They attach the original property, then they attach, so supposing, I'm not planning to, but supposing I will say A was to commit a crime. A commits a crime, does the robbery, earns, let's say, 20 lakhs. He then goes and buys himself a vehicle for 10 lakhs. And 10 lakhs he puts in the stock market. Now, there are two things. He also has 20 lakhs of money lying in his account. The ED will invariably attach the 20 lakhs in the bank account, the 10 lakhs worth of car, and the 10 lakhs in the stock exchange, which means while the proceeds of crime were only 20 lakhs, what is really attached is 40 lakhs, which is ridiculous. And that has led to some amount by the PMLA Appellate Tribunal, because this double attachment becomes a problem. Shares are bought, A does a crime, buys shares. Now, the shares become the value. The money is paid to X. X then does a transaction, the money goes to Y, goes to Z. The ED will then attach the amount in all 5 places. What's the legitimacy of that? So these become serious concerns, and these are issues which are evolving, and unfortunately it's taken a long time to evolve, to be clarified, but the law really needs complete clarity on double attachment. But this definition is also important from the ED's perspective, because sometimes the property is dissipated. Supposing somebody buys a car and then has an accident. Now the vehicle can't be brought back, it's been burnt. The insurance policy is lapsed, so you can't get insurance. So then the value of such property can be attached. So that's the kind of thing it was meant for, not this double and triple attachment. There is now an amendment which is by the Finance Act of 2019, and this has created an issue because it uses the word property derived as a result of criminal activity relatable to the scheduled offense, an ever widening definition. Scheduled offenses are those in Part A, C, and B, where the value is more than 1 crore. There are, whether it's fake currency, IPC, NDPS, specified offenses under the IPC. And this act has undergone many, many changes. 2005, it was brought in 2009, then 2013 amendment, then again an amendment in 2019. It's been an evolving legislation, perhaps because the original legislation was not as fine-tuned, and as the ED desired and got more and more powers, they've been demanding more and more, and as a result of which it has become a situation where they are prosecuting in a much larger scope. Before this amendment, the existence of a scheduled offense was a sine qua non. Now what is happening is the scheduled offense may or may not be proved, but the department ED can still prosecute, and that raises a very piquant situation, because the ED statement before the ED creates a situation where the ED can prosecute and convict a person based on those very statements. Now, that's a situation. In fact, that creates a serious and piquant problematic situation, because frankly, with the criminal investigation under the normal law, whether it's the CBI, the state police, for them to investigate, the investigation takes place in a manner where they have 161 statements. At the most, they can record 164s, and that debate is still underway, whether they should or should not be able to do that. But having come to that, as I said, this is a matter which will need some more deliberation, and the jury is out. The matter is yet to be decided in court, but a matter of some concern as to the divergence between scheduled offense and the there are challenges pending that will, as I said, have to be determined. Now, PMLA, by the 2009 amendment, as I said, delinks PMLA from the scheduled offense, and this explanation creates a certain concern. There is also an amendment in the deletion to the proviso to section 17(8). You can read it yourself. I'm not going to trouble you with that. But it creates a mechanism as to what is the basis to investigate in such matters. So how does this take place? Well, 3 concepts: placement, introduction of money generated into the financial systems, layering, conversion, movement of funds with the financial system or otherwise. So this is really, getting legitimacy to the money. And integration, once this money reaches a level where it is so interminably linked with legitimate transactions that it becomes distinct to try and divide it. So supposing you build, let's say, a multi-story building, 20% of the cost of that building is money which is coming through illegitimate sources or money which is proceeds of crime. So it becomes difficult, and that is the reason perhaps that the ED and the government keep seeking continuous expansion of their powers, and that is what has been happening in the recent past. So who can investigate is the next provision. You know, section 48 and 49, vast powers have been given to the Department of Revenue, the ED, to investigate. The principle of all of money laundering is follow the money. I don't know if you remember the story of Al Capone, the famous gangster in the 1920s. Now, you know, all these guys, they could only be caught. They were never caught for criminal activity. But finally, it's the income tax department, the tax department that went after them. And that is the reason legislation such as money laundering have come about. Because as we now realize over the last 80, 90 years, there is a great amount of generation of cash or monies in the non-legitimate economy, in the criminal economy. And if there is a black money economy or criminal economy, that generates funds which then can destabilize economies, legitimate economies of a country. And therefore it becomes obligatory on a state to ensure that not only do you tackle crime, but you also tackle the proceeds of crime. And in this, banking companies, financial institutions, intermediaries are supposed to be very, very particular. There was a time when you didn't need Aadhaar or any identification to open a bank account. People used to have undeclared bank accounts with lakhs and crores of rupees within India because there was no tracing. Now you have KYC norms. Banks are obligated to follow KYC norms. They're supposed to deduct tax at source. And therefore, there are various checks and balances to ensure that bank people don't escape from the banking system, and money is always trackable. You know, money is fungible. It's something which you can't really identify. But having said that, it's important that money should be able to track. And that is the reason Chapter 4 of the PMLA puts in these lot of responsibilities. The next question that comes to us is the money locatable? To do so, the Act has great provisions for survey, search and seizure. Survey is akin to the income tax provisions, and then search and seizure. So under section 16, there is a survey to be conducted. Under 17, there are searches of buildings, etc. Under 18, personal searches. 50, recording of statements. Arrest is 19, and provisionally attaching proceeds, property suspected to be derived from proceeds of crime is section 5. Sections 16 and 17 have a very interesting term, reasons to believe. These are reasons to be recorded. There are a couple of precedents I've cited for you. An income tax precedent under the income tax law, and then thereafter under other legislation. These are very important because these legislations have interpreted reason to believe, and recently in Mr. Chidambaram's case, this has further been interpreted. So, you know, the logic behind this is that when you have very stringent statutes, you must have a mechanism whereby the onus on the department, on the officer taking action, whether attachment or arrest, is strong, so that he has to discharge that onus, and you can't just take action under such a stringent legislation just because you want to. And these reasons have to be sent to the adjudicating authority, which is to determine whether an offense is made out or not. And then, of course, there are 30 days of seizure from seizure of free applications to be filed for retention of such a record. So those are other procedural safeguards. Most of these safeguards are akin to Customs Act, Excise Act, similar laws, similar fiscal statute with similar safeguards. Attachment requires reason to believe. There has to be material in possession of the director or authorized officer. And the test is the person possessing of proceeds of crime? Are these likely to be concealed, transferred, or dealt with to frustrate confiscation? Look, if a person has a house, he's not selling it. There's no logic in attaching it. I remember many years ago, there was a very interesting case which I did where Captain Amrinder Singh, the current Chief Minister of Punjab, was also named as an accused. And one of the things was that, the opposition said he's going to leave the country, he's going to flee, he's going to go to London, he has assets in London. And I remember Justice Kachu, who had been your Chief Justice in Tamil Nadu in Madras High Court, was then in Supreme Court, and he laughed and said, for heaven's sake, the man is the Maharaja of Patiala. He's not the Maharaja of London. He's not going to run away. He has more assets here. He's not going to leave his assets in palaces in India to go and live a life of a refugee in London. Having said that, there is an attachment period of 180 days. In COVID times, there has been an issue on this legislation. In fact, a challenge is pending in Delhi High Court because the department has moved for attachment has asked for an extension beyond 180 days without complying with the law. And this is the subject matter, as I said, of a petition before the Delhi High Court where a stay has been granted because they were trying to reattach the money after the 180-day period had lapsed. One thing I want to mention is there is the challenge to the constitutional validity of the second proviso, which is pending in Union of India J. Sekhar. There's the judgment J. Sekhar versus Union of India. This High Court decision also touches upon reasons to believe. So what are the stages of attachment? First, provisional attachment under 5.1. This is the preliminary stage. Second, a confirmation of the provisional order. And then finally, it should be not finality, it should be finally the order of attachment under section 83B. So the 5.1 order must be confirmed by the adjudicating authority. Who is the adjudicating authority? The adjudicating authority, friends, is an officer of the department normally. And this experiment of having departmental officers consider these issues and then come to an adjudication, whether in the field of income tax, whether in the field of, in the old days, FERA, customs, excise, and even under PMLA, has not been a successful proceeding. All it has done is add another layer of hardship to the litigant. It would be better if the first layer of challenge of adjudication lay before an appellate authority. I remember last year I was doing a case where, to my horror, the adjudicating authority wrote a letter to the department as to why they were not getting the interim orders of the Karnataka High Court vacated. That's not the job of an authority which is supposed to act in an unbiased manner. So these are the kind of problems you have sometimes when you have departmental officers who have to take a decision. They sometimes lose their perspective as to which hat they're hearing. I just saw that somebody raised a hand. I'll be happy to answer all questions in a little while. But if you allow me, I would like to first conclude this. It's got a few more slides left, and then we'll leave the floor open to whatever questions there are. As I said, there is a requirement to file a complaint under 5.1 before the adjudicating authority, and that complaint becomes. So there is this peculiarity of this hybrid procedure, but now we are living with it. What's a complaint? Not defined under the PMLA. There's no format. Section 2D, of course, talks about a complaint. And a complaint is not a police report. There are, of course, certain regulations which you may want to look at. There is another peculiarity in a PMLA prosecution. It begins with an ECIR, Economic Crime Information Report. Am I entitled to it? Well, I should be, but I don't get it. Is it an ECIR under the terms of section 154 of the CRPC? Because the CRPC applies. According to the ED, no. According to defense lawyers, yes. Frankly, it has to be. But that issue needs to be clarified. And it seems that whether it was the Customs Act, whether it was the Excise Act, The ability of departments to record information in their internal registers, then investigate with no intimation or knowledge to the accused, where the accused does not even have a right to get the FIR to know what is the starting point of investigation, is unfair and prejudicial. That's no procedure. I mean, it's not procedure established by law because there is no law. But this administrative mechanism of an ECIR being recorded, which culminates in a complaint, is something which is under consideration by the courts, and I hope that it will be dealt with at some stage. Now, we must remember that the recording of an ECIR becomes important because it is relatable, because the money laundering offense, though relatable to the principal offense, is not a parallel prosecution, should not be, though it is now becoming in terms of the new amendments. The offenses which lead to generation of proceeds of crime and charge of money laundering are distinct. I remember a beautiful decision, AR 1960 Supreme Court, I think it's called KK Khanna, whatever, if I'm not mistaken, versus Union of India. A very interesting case in relation to the context of misappropriation and breach of trust, where the Supreme Court held that for misappropriation, you don't need to show where money finally went. All you need to show is that a person was entrusted with money, the person misappropriated, did not return it when called for, and therefore that is all you need to show. You don't have to go to the ultimate conclusion as to where the money is landed up. This legislation, like all fiscal statutes, has these presumptions. So there's a presumption for records under 22(1). There is a presumption from records received from overseas, and if they're duly stamped, they're admissible, 22(2). There is a presumption in relation to interconnected transactions, that these are for the purpose of confiscation, etc. And for section 24 says that there's a presumption that a person holding proceeds of crime is involved in money laundering. Now, this burden of proving that these proceeds of crime are undated then shifts to the accused, and there is a normal practice of creating a number of reverse burden provisions, which is becoming the norm of the day. The constitutional validity of section 24 is challenged and is pending in the Supreme Court in B. Ramaraju, and there was a AP High Court decision is pending in the Supreme Court in the SLP. There are certain other petitions also which I've mentioned dealing with this issue. Numeraga is a very interesting decision under the NDPS Act. The issue of presumptions came up, and it's come up even earlier. Justice Sinha, in a landmark decision, clarifies that, presumptions don't just shift the burden completely. Presumptions require the prosecution to lay the foundational facts. If you don't lay the foundational facts, the burden will not shift, and that is the most important consideration. So these cannot be seen in isolation as if they are the last word of the subject. And this landmark decision in the context of NDPS Act on the interpretation of reverse burden, of course, presumptions were upheld, but it is very important to see this decision. Then we come to the bail conditions. We had the twin conditions under section 45, which was struck down. Very, very stringent conditions that a person must show that he is not guilty of such offense and not likely to commit any offense while on bail. Now, what does this do? This creates a problem. Let us say a person processes should cognizance is taken. Fine. You can say, I'm arguing for bail merely because cognizance is taken, summons I should, doesn't mean I'm guilty of an offense. But what happens when charge is framed? So the moment charge is framed, we have what is called a prima facie case. The fact that the accusations are good enough to send you for trial, that means a person charged with and to deal with twin conditions cannot at all prove his innocence till the trial goes on and must remain in custody. In any case, to cut a long story short, these twin indication and again short, they were sought to be brought back. So I've given you the prior to and the post amendment, and now section 45 has been amended. You'll see it that, and you'll see the portions highlighted in bold. A couple of colleagues have been asking for being allowed to annotate this. I'm not permitting it right now, but my request is after I'm done, please feel free, Mr. Ravindran, to share this with all your lawyer colleagues. This is my understanding of the subject. It's like a summary of what I understand of the Act. Anybody has better understanding, please amend it and send it back to me. I'll be happy to learn some law. This amendment is now under challenge in Jairam Ramesh versus Union of India, where there was a dismissal by the High Court. It's pending in the Supreme Court. The law is that legislature, by introducing an amendment, cannot overturn a judicial decision. Some high courts, Delhi in particular, has taken a view, Madhya Pradesh also, that the twin conditions are inapplicable, cannot be revived. And these are of course pending challenge in one case in the Supreme Court. The jury is still out, and we'll get to know in a while as to what the validity of the twin conditions is really, as now introduced. Like all special laws, there is a creation of special courts, designated special courts. Only they can try offenses. Vast powers under 44. Cognizance is on the complaint of an authorized authority. And the special courts don't have any committal process, though they are of the rank of a sessions judge. They're the same courts notified under the Prevention of Corruption Act by and large, and they do parallel trials of both. Cognizance is only, as I said, on the complaint of an authorized authority. Other offenses can also be tried, yet the CRPC applies in terms of section 46 and 65 to the extent there is no inconsistency with the PMLA Act. Like other statutes, there is section 70, which is the vicarious liability provision, like 138 of the Negotiable Instruments Act. The principles of law, failure to prosecute the corporate entity would be fatal. The earliest such provision, as I recall, I'm sure there are others, is the Official Secrets Act 1923. And it seems that each time the draftsman has really copied that legislation, maybe tweaked a few words, comma, full stop here or there. But that legislation in the past 100 years, that provision of vicarious liability does not seem to have changed to my knowledge. I don't know how it will pan out in the future, but right now it's almost verbatim copied since 1920s. An argument on the retrospective application of PMLA, as I said, is pending before the Supreme Court. Some views say that it can't be retrospectively applied. That's Obulapuram Division Bench of the Karnataka High Court challenged. Arun Mishra, Single Bench, Delhi High Court, Arun Kumar Mishra, pending. Now, just to come back to one little issue I want to say was, punishment under the Act, Section 4, is not for scheduled offences, but for laundering proceeds of scheduled offence. Therefore, the relevant date should be the date of offence of money laundering, not of the commission of scheduled offence. But these issues are pending consideration before the Supreme Court, High Court Division Bench. These are the judgments which you may want to see at your convenience. No discussion of the PMLA is complete without an understanding of the Black Money Act. The Black Money Act was inserted in the schedule. There's a notification. There are some issues as to how it is cumbersome, and there is a challenge pending to the Black Money Act before the Delhi High Court. We had an interim order. I'd appeared in that matter, but the Supreme Court set aside the interim order and sent it back with these observations, holding that it is the notification does not make it retrospectively applicable. And yet the challenge to the provisions of the Black Money Act remain. There are other challenges. And the question remains that while the Black Money Act is not retrospective. Can the PMLA be applied retrospectively for offences under the Black Money Act? Little confusing, but this matter will have to be determined someday. We also have the Fugitive Offenders Act, and under the Act, fugitive offenders is defined as any individual against whom a warrant of arrest in relation to a scheduled offence has been issued, he is left India or being abroad. So this was brought about in the wave of people like Mr. Malia, like Nirav Modi, all of whom left India, gone abroad, and it's interesting, refuses to return to India to face criminal prosecution. Now, for such persons, you have the Fugitive Offenders Act, PMLA, this has been introduced, and all authorities under the PMLA are authorities under the Fugitive Offenders Act. Of course, as you've seen, I've given you the two names of two famous personalities who are here. So thank you very much. That's all in the presentation as of today. And we will now come back to the main part of today's talk, which is let's expand the panel. Just give me a moment. Yeah, give me a moment. Let me now expand it. Give me a moment. Right, Mr. Ravindran?
Got distorted, sir.
Right, Mr. Ravindran, can you hear me?
Yeah, I can hear you, sir. Go on, sir.
I hope you heard my speech for the last 20 minutes, or was I in silent mode?
No, sir, no. I think you were searching on the computer, sir.
Sorry?
I think you were searching for something.
No. Did you hear me in my talk?
Yes, sir.
Okay, fine. I know because I just saw I muted it after I got on. Yeah.
Okay, sir.
Thank you so much. So,
sir, I think there are persons who will ask some questions to you, sir. Sneha?
they are most
Sir,
welcome. I will try and answer them. If I can't, respond right now, please feel free to share them to me, email them, and I will respond to them in writing, and then you can give the answers.
Sir, I don't feel that, sir. You will answer spontaneously, sir.
Please share this presentation for whatever it's worth to our friends who are here, whomsoever
Sure.
is here, and they are welcome to have it.
Sure, sir.
Okay.
Sir, good evening. I think the first person to raise his hand was Mr. R. Vivekanandan. He raised his hands when you had started the.
Yes, he did.
Mr. R. Vivekanandan? Because he hasn't even typed what was his.
Yes, he did raise his hand.
He just raised his hands. Mr. R. Vivekanandan?
He has possibly stepped out because we.
No, he's very much there. Mr. R. Vivekanandan, I have unmuted you. Okay, sir, he's just raised. I think Mr. Manimaran. No, I don't think so, sir. I'm not able to. They are not able to connect to you, sir.
They're not me or to them.
No, they are not able to. They have some a problem with respect to their internet, sir.
Oh, their internet. As long as it's not mine, it's okay.
No. You are very audible and very clear, sir.
I hope I'm audible and visible both.
Yes, sir. Definitely, sir. Any other person who would like to interact?
There's a request from Shaktivel to everyone. Please share the chart. Please tell her that this is to be shared.
Yes, Mr. Shaktivel. In fact, this program is going live on Facebook and it will also be uploaded in our YouTube channel. So everyone can view. It's going live on Facebook now, it will have a recorded version of it always on the Facebook. So I think there's one Divya, sir, who wants to ask you a question. Divya?
Thank you.
Divya?
Can you hear me?
Yes, Divya, you can go ahead.
Clearly.
But we are not able to see you.
We're not able to see you, but we can hear you.
Good evening, sir.
Good evening.
My question is specific and related to section 8.3 as well as 8.4, sir.
Right.
With regards to the immovable property alone.
Just a minute.
So,
Tell me. Yeah, go ahead.
can I, sir?
Yeah, please.
When the provisional order for attachment is confirmed by the adjudicating authority, then the right of possession is also taken away from the person. So even before exhausting all the appellant legal forums, even at the initial legal forum, taking away the right of possession, isn't it not against Article 14 and Article 21?
Look, normally what as I can, I'll just have to pull out that provision for a moment. Give me a split second. Huh?
Yes.
Because according to me, there is something there which is a little beneficial to you. Just give me a second. Sorry, just a minute. Just a minute. According to, just let me pull that out and I'll just give you your response in a moment. Just a minute. So you want me to see 8.3 and 8.4?
Yes, I.
Oops. Sorry, I seem to pull out a very old copy. Just give me a moment. It's a very... Just 1 second. Just got it. I've got it open. Now, tell me, so you want me to see 8.3, which says in the context of immovable property.
Yes,
Now,
sir.
why don't you see the proviso to 8.4? It says, provided that if it is not practicable to take possession of a property frozen under 1A, order of the confiscation shall have the same effect as if the property is frozen. So what they do is they take over the property as in a paper possession, but then they hand it back to you as a custodian of the property. And that is what is, it's not that you are ousted from the property. But yes, if you are sought to be ousted from the property, pending the determination, there is a legitimate problem.
Yes.
So in this regard, sir, if we are dispossessed due to the order of the adjudicating authority, and thereafter we go on an appeal, we go to the court and everything.
Tribunal.
Yes, the tribunal and all that, sir. And thereafter, if the dispossession or if it is reversed, then what happens, sir, to the property? I am dispossessed. Should always be on the paper wise. I should not be physically dispossessed. Is it not, sir?
You're absolutely right. That is the reason they have a proviso, as you will note for a moment, that there is a proviso, specific proviso under 4, which talks about possession of property not being taken over. But if you're dispossessed, you have to challenge this immediately before the tribunal and seek a stay, because the stay before the tribunal would operate on the dispossession order, and you will have to seek a stay of status quo ante so you can be put back in possession. Otherwise, the whole purpose of the stay order becomes nullified.
Okay, sir. So thank you very much.
And if I may just point out, you
Yes,
may
sir.
want to see section 17 for a moment. You see,
Yes, sir.
17 is very interesting. 17 talks about
Search and seizure.
entering, breaking a lock, etc. for getting
Yes.
to keys. And then please see 17, 1 capital A.
Yes, sir.
Please see 1 capital A.
Enter and search.
Yeah, where it says where it is not practicable to seize such disordered property, officer may make an order to freeze such property, whereupon the property shall not be transferred or other dealt with, except with the prior permission.
Okay, sir.
So no, the norm is for immovable properties, or for example, something which is capable, not which if it is moved from one place to the other. Let's say there are there is data, soft data. You can't move that. So then there is a freezing order, and that there can be a seizure order or a freezing order. And immovable property, my experience so far has been there are freezing orders.
Thank you so much, sir.
Thank
So
you.
there's one Mr. C. Arun Kumar. He has
Please.
posted his question here. Arun?
Mr. Kumar, very important question. Prior to the amendment, the position was that there was no crime. There can be no proceeds of crime. Now, there are two reasons why a closure report may be filed. It may be filed because of absence of sanction. If it's a technical reason, that would not apply. But if it was an exoneration on merits that no crime has been found out, if it is an untraced report, yes, sir.
So my question was, a person who commits an offence other than a scheduled offence, which is not mentioned in the schedule, and still he goes to launder the money, proceeds of crime, but he cannot be prosecuted. Why this parity?
No. Sorry, come again.
A person commits an offence other than a scheduled offence,
right?
And he launders the proceeds of money or proceeds of crime, whatever it is. So then he cannot be prosecuted under the Act 2002.
Yes.
Why this parity? When the object of the act is not defeated, sir?
I must tell you, the policy of the law was to only make certain class of offences prosecutable. That is the reason you see that initially 409 was not there. PC Act came later. So as the law has developed, they brought in more and more offences under this ambit. And the idea was to target the more serious offences which have an impact on society. I assume that seems to be the legislative philosophy. But as you rightly noted, that for those non-serious or non-scheduled offences, there is no remedy under the Act, but there is always remedy under the CRPC 451 to 457. There's that limited mechanism. That's the mechanism that exists. Also, certain other legislations, if you look at, for example, the Forest Act or the Wildlife Act, now those legislations also have provision, and you may want to see that. Okay. I hope I've answered your question.
Yes, sir. Thank you.
So there's one more question from Mr. Kali Charan. Kali Charan?
You have the name of one of my favorite cricketers, Alvin Kalichar. I used to be great as a kid. I used to admire the man. What a talented chap.
Kali Charan?
Sir, am I audible, sir?
Yes, you're
audible, but we can't see you.
And a sir would like to see you, Kali Charan, because he has to relate to his you with his favorite cricketer. So why don't you?
I have a poor network connection. Yes.
Okay.
Don't worry. We understand. A lot of friends. Miss Indra is also here. Thank you.
Sir, what happens if the LEA after investigation finds a closure report that the offences?
Can you just type this out, because there's a little the voice is cracking a little.
Yes, sir. I will.
Just type it and we'll answer that. Meanwhile, we'll take another question. Any other questions?
Sir, I think Mr. J. Ravindran himself wants to pose certain questions to you, sir.
The tough task. Yes, please.
Ravindran, sir?
Can you hear me?
Yes, I can.
Yes.
I can see you and hear you.
It's really a tough task, sir, for me to ask you questions. Sir, the properties derived out of criminal activity can be attached.
Yes, please.
But what the authorities do, instead of attaching those properties, at their whims and fancies, they go and attach properties
Equivalence.
which was purchased much before the alleged criminal activity.
You're
The
absolutely right.
properties which is alleged to be out of criminal activity is still there with the accused.
You're absolutely right.
Can it be done at whims and fancies, sir?
Only for foreign properties in terms of the, there's an amendment relating to properties abroad. So if the property is taken abroad, then the Indian equivalent can be attached. But equivalence principle can only apply for Indian proceeds of crime, can only apply if the proceeds of crime have been destroyed or extinguished. Otherwise, the law needs to be clarified. And since Parliament doesn't seem to be doing it, it will eventually need to be clarified by the courts that you will only go after equivalence if the proceeds of crime is extinguished. That needs. The tribunal has taken certain judgments where they've hit a double attachment. Justice Manmohan Singh had taken a view. You can't have double attachment. You can't go for equivalence when the asset exists. Let's say a person buys a house. I mean, he invests money in immovable property. He buys an immovable property for 1 crore of rupees. For whatever reason, the property value sinks. The property then becomes for 90 lakhs. Now that asset exists. Can equivalence be attached? So these are issues that need determination, and it's unfortunate that a lot of these issues have not been determined by courts over the last 15 years.
Yes.
It needs to be seen. Okay.
So one more thing, sir. You said only when there is a reason to believe that the property will be dealt with or disposed of, the ED should come by way of an attachment. As a matter of practice, what happens when there is a scheduled offence and FIR is filed, automatically ED steps in as a matter of practice.
You're absolutely right.
Then the reason to believe goes. It comes as a matter of practice. Once an FIR is filed by the investigating agency, automatically when there's a scheduled offence, ED steps in and proceeds further.
Absolutely.
That is a question of reason to believe, sir. That is absolutely.
You see, reason to believe is a safeguard the legislature has put in a number of legislations. It is for the courts to enforce the requirement of reason to believe. In the 70s and 80s, lots of judgments in the context of customs and excise, gold control on reason to believe. Unfortunately, that principle is being diluted because remember one thing, all these laws are becoming more and more stringent with the reverse burden. So today, the reason to believe has been reduced to the whim and fancy of the investigator. There is no legal requirement. In fact, even in the CRPC for arrest provisions under 41, reason to believe has been introduced, but that is also being diluted, and it is for the courts to assert themselves and give a value to this and not give a very long rope, because all these agencies are using this long rope not to hang themselves, but sometimes to hang innocent people. And it's becoming a purely discretionary exercise of power, very contrary to what the statute requires.
Sir, thank you, sir. I personally feel, sir, more than it is being used, it is being misused, sir, the PMLA. This is what I personally feel at my personal level.
I don't think anybody can legitimately disagree with what you are saying. There is an increase in the use of powers under the PMLA, and by enhancing their powers, there is a fear psychosis that has come in the minds of people as to the manner in which this power is being exercised.
Thank you, sir.
Now, my pleasure. There was a question that gentleman wanted to put.
Kali Charan, sir.
Has he put
Sir,
it down?
yes, sir. What happened? Kali Charan.
What happens if the LEA after investigation? I've got the question.
Yes.
So Mr. Kali Charan's question is, what happens if the LEA, law enforcement agency, after investigation files a closure report that offences are not made out? Can the PMLA complaint survive? Well, traditionally, prior to the 2019 amendment, the PMLA prosecution could not exist in the absence of a conclusive finding of proceeds of crime having been committed. Today, that dichotomy has been brought in by the amendment to the legislation, where the PMLA prosecution is not predicated on a conclusion of a crime having been committed. And therefore, this closure report principle is create a closure report in the principal offense and the scheduled offense can lead to a situation where the prosecution can go on irrespective of the closure report. And that is a matter which needs consideration by the Supreme Court at the earliest. I don't think it should be allowed to coexist because it's illogical to say the least.
Thank you so much, sir. Any other questions to be asked? Ravindran, sir, I think you would have a question because that's what is much debated by you in the office with respect to the scheduled offense and the amendment coming. I think it would be nice if you could ask, sir, because that's a much debated topic in the office. It's ferociously, sir, for that.
No, we'll have it on another day. Not today. That I don't want to. Sir, are you? Sir,
Yes, please.
I really thank you, sir, for this session. The session was very informative and educative, sir. We learned a lot. Though I had opportunities to learn a lot from you in person, lots of advocates learned a lot from you, sir.
Thank you so much. It's been my pleasure entirely. I saw some people coming and going, so I hope you can share the presentation. I think that may be
Sure, sir. Whomsoever they want, sir, I will share, sir. That is a pleasure, sir. So once again, I thank you, sir. Stay safe, sir.
Thank you so much. Thank you
Stay
so
safe.
much.